5 seconds to go. Start. Section 52 of Juvenile Justice Act 2013, referred to by the petitioners, also refers to the facts that court has to satisfy itself as to the legality and propriety of any such order. As such, the factual findings of fact cannot be upset by the court unless and until it is found to be perverse. In the present case, where factual finding has been given by the court below, therefore, there is no illegality or impropriety in the order. As such, there is no question of interference with the findings of the court below. In the instant case, the trial court has given finding of fact relying upon the evidence and has acted in conformity with Rule 74 of the Rules of 2014, and that there is no perversion in the findings of fact. As such, the trial court has not committed any illegality or impropriety which warrants interference in this revision petition. Accordingly, this revision petition is dismissed along with connected criminal miscellaneous. Record, if any, be sent down. Interim direction, if any, shall stand vacated. In view the aforesaid, the appellant state is here before this court with the present appeal. Mr. P. S. Patwalia, the learned senior counsel appearing for the appellant state, vehemently submitted that the orders passed by the CJM Kathua and the High Court could be termed as palpably erroneous and thereby rendering the dispensation of justice to a mockery. The learned senior counsel came down very heavily while criticizing both the orders, submitting that the two courts have conveniently ignored about the statutory rules governing the determination of age of a juvenile. He submitted that there is no cogent, clear, and convincing documentary evidence on record to suggest or indicate that the respondent was born on 23rd October 2002. He invited the attention of this court to an order passed by the Executive Officer Municipal Committee, Hiranagar, dated 15th April 2004, specifying the date and place of birth of three children of Om Prakash Sangra. This order, dated 15th April 2004, came to be passed pursuant to an application said to have been filed by the father of the respondent herein, namely Om Prakash, under Section 19(3) of the Registration of Births and Deaths Act 1956, read with Rule 19(3) of the rules. The order reads thus: application under Section 19(3) of Registration of Birth and Deaths Act 1956 with Rule 19(3) of the J&K Registration of Births and Deaths of Birth Certificate of the son Rahul Sangra. The applicant has moved an application for the issuance of date of birth certificate. The applicant Om Prakash Sangra has stated that he was born on 23rd November 1997, 21st February 1998, 23rd October 2002, village Hiranagar, Tehsil Hiranagar, and submitted that the birth has not been recorded by the MC Hiranagar. The applicant has filed an application in this court supported by duly sworn affidavit averring therein that due to ignorance of the concerned, his date of birth could not be recorded. The applicant has examined eligible son of Ram Krishan of Tehsil Hiranagar besides himself as his own witnesses in support of the averments made in the application. The applicant has supported the contents of the application and Hiranagar Ward number 7 District Kathua witnesses appearing for the applicant have corroborated the material averments of the applicant. I have gone through the application affidavit and the statements of witnesses from the above. It has been established that the applicant's son Rahul Sangra has taken place at village Tehsil Hiranagar on 23rd November 1997, 21st February 98, 23rd October 2002. Keeping in view the material placed before this court, it is ordered that entry of the above named applicants be made in the register of, as mentioned above, in terms of Rule 19.3 of the Registration of Birth and Death Rules. The child particulars are stated as under. The learned senior counsel submits that no reliance could have been placed on the aforesaid order for the purpose of coming to the conclusion that the date of birth of the respondent herein is 23rd October 2002. Our attention was drawn to the fact that the first child of Om Prakash, namely Rahul Sangra, is shown to have been born on 23rd November 1997, whereas the second child, that is, the daughter, namely Riya Sangra, is shown to have been born on 23rd January 1998, that is, just within 3 months from the date of birth of the eldest child. The date of birth of the respondent herein is shown to have been 23rd October 2002. As against the aforesaid, the learned senior counsel invited the attention of this court to a birth certificate said to have been issued by Modern Public Higher Secondary School dated 6 September 2017. The same reads thus. Stop.